My name is Councilmember Jaiza Page, and I chair this committee, and I'm joined this evening with Councilmember Emmanuel Remy. The intention of this public hearing is to review the 2019 operating budget for the Judiciary and Court Administration Committee. This includes the Franklin County Municipal Court, the Columbus City Attorney's Office, and the Franklin County Municipal Clerk of Courts. And we have each of those offices here with us this evening. And I would like to begin with the Columbus City Attorney's Office, and we are joined this evening by Columbus City Attorney Zach Klein. Thank you.
Thank you, Chair Page, and to Councilmember Remy, other members of council, and to the Honorable Judge Barrows is here in the Municipal Court. I'm Zach Klein, Columbus City Attorney, to talk about our proposed budget and certainly the support that we've had from this council as well as the administration. And just want to say that the partnership and the collaboration that we have is a tremendous one, and one that I think we're doing great stuff for the city of Columbus. The city attorney's budget for fiscal year 2018 was $14,740,244. And as of the end of the third quarter, we are projected to spend $14,638,233, which is a savings of $102,011. The fiscal 19 budget is essentially a continuation of the 2018 budget. The city attorney's office budget is projected to be $14,653,172. However, as you know, Chair, every agency will realize a savings with healthcare costs. My office employs approximately 149 FTEs who focus on prosecution, real estate, labor, litigation, general counsel, the Solicitor General's office, as well as the Zone Initiative. This year, I did create a new section on my tenure as the Columbus City Attorney, the Solicitor General's office, and to date, this office has led our amicus work, affirmative litigation, and policy direction. I plan to add an FTE to this section next year, and the office will focus on building external relationships with key players in the national and Columbus legal communities. Among other things, my office has taken the lead in participating and filing in the opioid class action lawsuit, the lawsuit against Major League Soccer, which we've had notable success as of today, and also drafted language that this council is familiar with as it relates to guns and gun violence. While these are some of the major highlights from 2018, I'd like to provide a brief section overview, if that's okay with you, Chair. First, in no particular order, the General Counsel section, which is led by Josh Cox. It serves as the primary legal counsel to all city officials on matters that involve city services, legislation, contracts, zoning, and other vital issues related to the day-to-day operation of city government. They also assist in the legal review and practical implementation of various development projects to foster the growth of our community. Last year, the General Counsel attorneys reviewed 1,415 contracts for various city departments involving expenditures of approximately $1 billion, and reviewed and approved a total of 1,988 ordinances and resolutions. The next section is labor and employment. This section is headed by Pam Gordon and is responsible for handling all labor and employment-related litigation involving the city, and renders legal advice to city officials and managers on labor and employment matters involving 6 collective bargaining agreements and thousands of full-time and part-time city employees. The section started 2018 with 99 cases pending in various forums and currently has 127 pending cases. And over the course of the next year, 59 cases were, or over the course of the past year, 59 cases were resolved. 41 of those were successfully resolved in the city's favor, including 8 arbitrations, 11 cases with the Ohio Civil Rights Commission and Equal Employment Opportunity Commission, 22 court and administrative cases. Of the remaining 18 cases, 14 were settled. 1 arbitration resulted in a split decision. 2 arbitrations were decided in the union's favor, and 1 Franklin County Court of Common Pleas case was decided in the union's favor. Additionally, our labor and employment attorneys field numerous calls and requests for legal advice and assistance unrelated to pending cases, and participated in training and update sessions for various updated sessions on the city on various legal issues. The next section is the litigation section. It's chaired by Tim Magnan. The litigation section defends the city and its employees in all types of civil litigation in various courts, state and federal primarily. In 2018, the litigation section was assigned to handle 37 new cases that were brought against the city, seeking a total of approximately $3.4 million in damages. A total of 50 cases were closed this year, which resulted in the city paying out $284,300 out of a total prayer sought of $24.2 million. So being able to resolve these cases for $284,000 when the plaintiffs were seeking $24.2 million. A total of 78 cases were active. are still active. The next section is the claims section. It's chaired by Brian Shin, who's to my left. The claims section investigates pre-litigation tort claims against the city that exceed $2,500. They also manage the collection of delinquent debt owed to the city after our departments have exhausted remedies prior to initiating litigation. If a matter cannot be resolved in the pre-litigation stage, then the claims section files suit. As I read this, I feel bad that I just don't have Brian reading it, so apologies, Brian. The combination of both in-house and outside collection agency delinquent tax collections brings in millions of dollars to the city each year. In 2018, as of November 30, we have brought in more than $4.7 million to the city. The claims section filed 2,109 tax cases and collected close to $2.3 million in delinquent city income taxes. The section also collected $217,000 on behalf of non-tax clients through both court action and direct debtor contact. There were 82 new claims over the $2,500 threshold through November 30, 2018. 21 were settled, 46 were denied. Some of these claims were filed in 2017, with their investigations continuing into 2018. In total, $70,339.17 was paid on behalf of the city departments to settle damage or personal injury claims filed through November 30, which actually represents a 38.8% decrease over the same time last year. The next section is the Police Legal Bureau section. Our police legal advisors provide comprehensive legal advice to the Columbus Division of Police on a wide range of legal issues, delivering around-the-clock real-time advice to police personnel because they're on call 24 hours a day, 7 days a week. They also provide over 300 hours of legal training to police directly, to their recruits, and through in-service training. The demands on the legal advisor section by police for legal training has continued to increase over the past several years, and more legal training was provided over the past 2 years than ever before. We anticipate these demands will continue to increase as more legal training is required. Ongoing in-service legal training for all current officers takes place on all shifts and affords face-to-face contact. And our police legal advisors also go to police roll calls to take questions in real time. Those questions range from approximately 30 to 40 inquiries a day. Our police legal advisors write and distribute legal memos to all officers for up-to-date legal information. And they also provide videos which are required viewing for all officers, and they're typically 2 to 4 minutes in length and cover an important topic. I think it's also important to note that our police legal advisors not only are so good that they train the Columbus Division of Police, but their advice is also sought across the state of Ohio as well, and we're certainly willing to provide the information and the training videos that we share across departments in the state. Our prosecution division, it's led by Chief Prosecutor Bill Hedrick and Deputy Chief Prosecutor Joe Gibson. They prosecute all misdemeanor offenses in Franklin County Municipal Court for the City of Columbus, the State of Ohio, the unincorporated areas of Franklin County, under contract for the municipalities of Canal Winchester and Worthington, and the villages of Riverlea, Urban Crest, and Valley View. We have 17 courtroom prosecutors, 5 specially trained DV prosecutors, 2 arraignment team prosecutors, an environmental court prosecutor, an administrative assistant, and 4 legal support staff. The division prosecuted more than 116,000 misdemeanor cases last year, something I'm sure the judge is very well aware of. With an average of 6,622 total cases set for post-arraignment hearings each month, the trial staff handled an average of 441 active criminal cases per docket per month. The prosecution division also houses the prosecution resource unit, domestic violence and stalking unit, and the appellate unit. The domestic violence and stalking unit handles all DV violence and stalking cases for the office. They also provide education support, crisis intervention, and overall assistance to victims. 5 specially trained prosecutors handle all of these potentially lethal and complicated cases, which include but aren't limited to repeat assaults, egregious acts of violence, and victims that are high risk, including the elderly, pregnant women, children, and disabled. Last year, the DV unit prosecuted 4,419 domestic violence cases and provided victim advocacy to 5,500 victims. The next is the real estate division. It's headed by Dave Peterson. It's responsible for the acquisition of all real property interests needed by city departments, the provision of legal assistance with regard to all real estate matters, including the sale and leasing of property, utility easements, right-of-way dedications, and matters related to real estate property taxes. This division also provides legal and negotiating advice for a number of major transactions, including the acquisition of 373 acres for future disposal of water treatment for residents. The real estate division also handles deed and instrument preparation and other assistance related to the city's land bank, involving more than 235 deeds. Next is the Zone Initiative, which I know the chair is very familiar with. The Zone Initiative is chaired and led by Steve Dunbar. They work closely with the Division of Police, Code Enforcement, Health, community groups, and residents, and our zone team focuses on eliminating public nuisances that blight our streets and undermine neighborhood safety and integrity. Whether it's abandoned or deteriorated properties, drug houses, non-compliant businesses, open dumping, street prostitution, illegal after-hour clubs, excessive noise, or trash or debris, this unit seeks to eliminate those problems. It's staffed by 5 attorneys, each who staff one of the 5 police zones, and they attend approximately 200 community meetings, 150 police meetings, and 150 client meetings throughout the year. The unit is involved in the liquor objections, what this council just heard last night, and the zone team also has objected to not only liquor permits, but also under the hotel-motel legislation has objected also to 4 hotel-motel permits in December of 2017. This year, we filed 410 nuisance abatement cases due to code violations, while 109 properties were referred to the city's VAP team for demolition. We also filed criminal activity nuisance abatement lawsuits to close down 18 drug houses, 2 apartment buildings, 5 market and carryouts due to violent crime, drug sales, illegal alcohol sales, and 1 massage parlor due to prostitution activity. The final section is the Solicitor General section. It's headed by Laura Baker. And attorneys in this section prepare filings and oversee complex appellate litigation, assist the General Counsel in advising City Council on legislative matters. They act as policy counsel for the City Attorney, primarily on issues pertaining to criminal justice and criminal justice reform, and serve as members of the affirmative litigation team. This is a proactive area of the office that I created when I became the city attorney for us to engage in civil rights litigation, engage in offensive work that in representing the city of Columbus and its people, and making sure that folks aren't taken advantage of, and making sure that we exercise certain pieces of litigation and exercise our rights to protect all those in the city of Columbus. So with that, Chair, I would like to close my remarks before entertaining any questions of just congratulating you on elevating to the bench. When I served as council president, have always been a very good friend and ally, and I think that you're going to be a tremendous judge, and I wish you the most success. Remember us back at the city when you're on Common Pleas Court.
Thank you, City Attorney Klein. Are there any questions or comments from my colleagues? Councilmember Brown.
City Attorney, would you elaborate just a little bit more on the opioid plan in sense of what the objectives are and since what you're trying to get accomplished with that?
The opiate plan or the opioid litigation?
The
Mr. Brown?
opioid plan.
The action plan. So as you recall, Councilmember Brown, the mayor and the county commission and we asked the Adam H. board to seek recommendations and input to create an Franklin County opioid action plan. And so Adam H. went out and talked to various departments, various social service agencies, and came back with an action plan. That plan was housed in the city attorney's office, for the 2017 and 2018 action item plan, we got that up and running. So we have accomplished many goals that Adam H., being the experts in the field, recommended that the city undertake in order for us to make a dent on what is becoming an increasingly difficult addiction to opioids and opioid abuse. We have now, after talking with the mayor's office and the county, now that the plan is up and running, are transitioning that plan over to the city and the Department of Public Health. We feel that it's better leveraged within the Department of Public Health for several reasons, one of which is that several of the action items for the 2019-2020 part of the plan actually require the Department of Public Health doing the implementation. So, just from an efficiency standpoint, didn't see that it made a lot of sense for it to continue in the city attorney's office when the Department of Public Health was responsible for a lot of the implementation.
Thank you. Councilmember Remy.
Thank you very much, Councilmember Page. City Attorney, Mr. City Attorney, nuisance properties have been on the news quite a bit in 2018. How does the city attorney's office plan to prioritize prosecution of absentee landlords in 2019? And then how does the proposed budget promote this, your office's activities in this area?
Thank you, Councilmember Remy. As you noted, we have taken a very aggressive stance on vacant and abandoned properties, nuisance properties, properties that are businesses that are truly criminal enterprises. That priority will continue under my leadership as the Columbus City Attorney. To give credit to my predecessor, Rick Pfeiffer, he started the Zone Initiative, which has allowed us to focus in conjunction with the Division of Police and various departments within the city of Columbus to identify those problems, to do the underage buys, to do the inspections that are necessary in order to shut those properties down because of the detriment and the problems they have on our neighborhoods. It really does undermine the integrity of strong and safe neighborhoods. And in fact, this year, Councilmember, we filed the largest nuisance abatement lawsuit in the city's history, involving hundreds of units. We're hopeful to have a resolution of that. It's amazing the nuisance property gets a lot of landlords' attentions. As it relates to problem landlords, as long as we can locate who the landlord is, and that problem, especially as it was rising in 2008 and 2009 with LLCs and shell companies, isn't such a big deal as it was back then. We're able to identify the landlord. And frankly, our focus is to abate the nuisance, is not to drag anyone through the court proceeding. If many of our cases are rectified and solved by sending a letter or having a phone call with the landlord. The ones that you end up seeing on TV are ones that are not responsive, that are digging their heels into the ground, that don't want to change. That's unacceptable. And me and my team will go after them with the fullest extent of the nuisance laws available that this council has given in addition to that of the state of Ohio. It will continue into the fiscal year 2019.
Excellent. Thank you very much.
Thank you. Any more questions? And thank you, City Attorney Klein, for that proposal and for introducing it to council.
Thank you.
Our next speaker will be the Honorable Judge Ted Barrows of the Franklin County Municipal Court, and he has with him this evening Emily Shaw, Court Administrator, Molly Gautner, Chief Probation Officer, and Tanika Jackson, the Court's Finance Director. Thank you, Judge Barrows.
Thank you very much, Council Page. Council members Remy and Brown, it's my pleasure to address you on behalf of the Municipal Court to talk about our 2019 operating budget. I would like to offer kudos to the Finance Department. I think the last time I spoke publicly, I took Mr. Lombardi to task somewhat. We appreciate their support and guidance through this important budget process. The Court's 2019 budget is, as recommended by the Mayor, amounts to $19,346,086, which is not appropriate to meet our 2019 operating expenses. The Court's general fund budget request includes $539,448 to provide essential contract services for evening and weekend building security, as well as the move of 3 employees from the security fund to the general fund. And this action continues the process that started several years ago and will allow the security fund, as intended, to provide for the purchase, upgrade, repair, and maintenance of the very expensive security equipment required to ensure the safety of every person that visits the municipal court. Now, this is not your grandfather's municipal court. So there are things we are doing now that the public may not recognize or be aware of that I want to highlight a little bit. And one of those is an additional general fund monies coming from this budget will continue to support the specialized dockets program. Over the past 13 years, 5 innovative and problem-solving dockets have been created, certified by the Ohio Supreme Court, and are actively operating at our municipal court. The court has developed valued partnerships with other federal, state, and local government agencies, as well as private treatment providers, nonprofits, and others to familiarize program participants with the services that are available to them. Specialized dockets focus on mental health, drug and alcohol dependency, human trafficking, and a program dedicated to our military service members and veterans who experience multiple interactions with law enforcement and the justice system. These dockets help the court provide wraparound care so that the underlying issues that contribute to a participant's criminal behavior may be successfully addressed and resolved. The specialized dockets have reduced overall number of jail nights, improved community safety through lower recidivism rates, reunified families, and have returned many participants to a productive life, contributing to the community in a positive way. The Court's 2019 request of $340,000 from the City to support the Specialized Docket Program is a carryover and remains the same amount as since 2012. County Commissioners continue to echo their support and are pledging an equal match in the amount of $340,000. The Court offers its sincerest thanks to you for helping us maintain these life-changing dockets. The Court's appreciative of the general fund monies provided by the City for the operation of the Court. I'd also like to express appreciation for a couple of expansion requests that were granted with the 2019 budget. You know from my previous statements that I don't like coming back to this council and asking for money beyond our budget. I believe in doing it right the first time, and I complained about the fact that we had to come back and ask for money for our work release program. So I want to tell you how much I appreciate the addition of work release funding to the Court's 2019 budget. This program is a proven and valuable sentencing option, providing an alternative response for mandatory jail sentences. It's cost-effective and appropriate condition of pretrial release or probation supervision and allows judges to consider this residential community resource as a measured and appropriate response to probation violations. The City's continued support, as well as the additional financial assistance of the County Commissioners, is a testament to the positive steps that can be made when government works together. In addition, we appreciate the City's investment in funding our Self-Help Center's managing attorney. The Self-Help Center has three primary functions: to increase access to justice for self-represented litigants, to provide a positive point of contact between the court, the clerk's office, and the community, and to provide operational cost savings through increased efficiency. This position will provide individual and specialized help to self-represented litigants who are attempting to navigate through the complex court system. As you know, the Center assists with multiple case types, including record sealing, small claims, general claims, and commercial debt collection. And echoing one of the complaints from the last speaker in the previous session, eviction cases, landlord-tenant disputes. We have people who can assist people in getting through the process, whether it's a rent escrow hearing or whether it's an eviction action, and direct them to assistance so that they can be well represented in our process. But there are two expansion requests that were not funded, and I must take this opportunity to appeal to Council to find funding for these two expansion requests. The first was a request for continuation of the high-risk domestic violence officer and the domestic violence assessment specialist positions. These positions were funded by Council for 2017 and 2018. If I may, I'd like to have our Chief Probation Officer, Molly Gauntner, speak on behalf of the Domestic Violence Unit.
Thank you, Your Honor. Chair Page, Council members Remy and Brown, thank you very much. I'm Molly Gauntner. And just want to underscore again what the judge said, that these are not new domestic violence unit positions. They are existing positions that we are hoping to make permanent in the budget, and they were generously made possible through discretionary funding through Council, so thank you very much for that. The two positions in question are, one is a domestic violence assessment specialist, and the other is the extremely high-risk domestic violence supervision officer. And this high-risk supervision response allows for a smaller-sized caseload and a very intense and containment response to this extremely high-risk subset of our domestic violence units. These positions were created in order to be in line with evidence-based practices in the supervision of domestic violence offenders. And these practices call for a robust and comprehensive assessment process that contains specific domestic violence assessment tools. And it also calls for a differentiated supervision response to the population, knowing that not all offenders require the same amount of supervision, programming, and have different needs. And it allowed us to target our limited resources to these most high-risk individuals. And one thing that's been very nice is when there's ever a tragic incident that occurs in the community around a domestic violence incident, when we look at the recommendations that are made, having a specific assessment response and a response for the highest risk individuals are very often recommendations. So we take pride in knowing that we've been able to kind of fill those needs. The assessment function specifically allows for the swift identification of an individual's risk level, and it clearly delineates the needs that that particular offender needs in order to reduce recidivism and achieve public safety. And because of the importance and success of these two specific functions, we have been able to leverage these positions to receive additional grant funding and support from our partners to enhance these responses. One of the grants that we're able to get because of this response is with the Columbus Division of Police, and they have allocated some of their grant funding and give us 8 hours a week of law enforcement assistance for that high-risk individual. They identify the highest risk warrants that exist, and they go out with us to help to apprehend these individuals. And it's nice to know that we're being proactive, especially in light of the dispatches series on outstanding warrants. It helps in assisting, making sure that stay-away orders are being attended to. So it's been very, very, very helpful and is reliant on this continuation of this funding. And it also allowed for one of our batters intervention programming to step up to the plate and say they want to provide a specific, intense, and specialized program for these offenders that they're doing currently in the prison system, and they offered to do it in the community in order to enhance what we are doing. Additionally, because of what we're doing in the domestic violence unit, we've quickly become a model around the state, and not just the state, but actually around the nation. It is not uncommon that we receive inquiries from other courts and probation departments consulting on what are we doing, how is our assessment process working, how are we managing to differentiate supervision approaches. So that's very, very nice. We've also been asked on numerous occasions to present on our model at various conferences, both in the state of Ohio and actually at other states. We were just recently in the state of Kentucky. And one thing we don't want to do is go backwards. We are continuing to make strides. So again, I respectfully request that council continue to fund these two positions that allow us to perform the functions that the community has come to rely on us for. And with that, we promise to continue to enhance our services and stay relevant and move forward where the research says we need to be. Thank you.
If I can interject really quickly, Your Honor, I'm sorry. What was the financial amount for this, or the dollar amount, I'm sorry?
Thank you, Councilmember. It is $155,000.
Yep. Thank you, Molly. The second unfunded request was on the heels of that, is for a request for 5 additional probation officer positions. And Molly made reference to the fact that we have engaged in an evidence-based practice, including adopting the principles of the risk, needs, and responsivity principles. This is, once again, not your grandfather's probation department. It's not one size fits all. And when I say to somebody, you're going to be under community control for the next 2 years, I know that that person's going to go down to the probation department and be subjected to screening tools to determine their risk for reoffending and their needs for services to keep them from reoffending. And then from that, they are categorized into high risk, high needs, and then intermediate down to low risk, low needs. People that are low risk, low needs, we have very little that they have to do. They have to stay out of trouble. They have to show up for group meetings 4 times a year, and we just kind of keep track of them. We're available if they need their assistance, but we don't have the probation officer caseload for those people who really don't need a lot of supervision. All the way up to the high-risk, high-needs people, and we have probation officers with smaller caseloads that see these people much more regularly, require them to do many more things that we hope are inclined to teach them how to conduct themselves in the community so that they don't come back. So it's a model that's in place, and what we found is the people who are testing at high risk and high needs are a greater number than we thought. We think it's worthwhile in investing because the return to the community, if we can change people's ways of thinking so that they don't reoffend, not only in terms of safety for their family members or in the community, but for their better way of life, is worth the additional investment. So for that purpose, the second unfunded request was $363,345. And we are hopeful that Council will consider helping us along in those lines. So the final item that I need to discuss is one of those things that only budget wonks know about, which is the vacancy credit. We all understand that in an organization as large as ours with 160-plus employees, some people will retire, resign, leave during the course of the year, and then we go through a process of hiring them. During that period when nobody's filling that, we're not making those payments, it's called vacancy. In the past, we've generally submitted to the Finance Department a vacancy credit, an anticipated vacancy credit in the neighborhood of 4.5%, which is what we asked for this year. The Finance Department came back and imposed a 5% vacancy credit. We checked historically, and it looks like generally we're getting 4 or 4.5%. My concern is, once again, having to come back to council in the third quarter and saying we're going to run out of money in our budget to pay the people that we have because the vacancy credit was unrealistic. So given that, it's our request that council will restore the funding that would help us overcome the anticipated shortage. We're thinking that the anticipated shortage is probably in the neighborhood of $125,722. That would keep me from coming back and barking at y'all in the third quarter if it looks like we're going to run short. I'll do it if I have to, but I'm always embarrassed because I like our budgets to meet what I think they're going to hit. And certainly the prospect of laying people off because of poor budget planning is not one that I think would look good to us and to the council or to the city at large. The court employs restorative and therapeutic justice as a means to offer the programming and intervention responses that are proven to be more effective tools to reduce and prevent recidivism. The court has proactively engaged and received favorable responses and continued collaboration with our other government partners, council, the mayor, Common Pleas Court, the county commissioners, and the sheriff, to name a few. This partnership and sharing of resources is essential toward long-term program sustainability and success, and will lead to greater program efficiencies, cost-saving measures, and increased resources, all of which affect the court's ability to be problem solvers. Chairperson Page, thank you for this opportunity. I would be glad to answer any questions that you or other members of council may have, and if I can't answer them, my team here's got all the answers.
Thank you, Judge Barrows, and thank you, Molly. Councilmember Remy?
Perfect. Thank you very much, Judge. Appreciate that presentation. I just had a question. What kind of efficiencies have you found in being able to reduce oversight of low-risk offenders?
I'm going to turn that one over to Molly because she's probably got the exact numbers in terms of probation officer per person supervised.
Thank you, Councilmember Remy. So when we first planned to restructure the department to be risk-based, we kind of took a look at our current staffing allocation and the field's target caseload size for the amount of supervision for each risk level, and kind of tried to stay as true to that as possible. So we are able to, for 500 low-risk offenders, we are able to allocate just one probation officer to that function, but we also employ an automated reporting system that helps that, where there's still the accountability option, making sure they're meeting any financial obligations, anything else. So that freed up several officers then to move to our caseloads where we want to do behavior change and spend that time doing skill building. So there's one officer to the low-risk population. Our low-moderate risk population, we were able to, and that is probably the largest volume of our offenders. There's approximately 2,000 low, moderate risk offenders. We're able to allocate just 4 probation officers to that function because we contract for group facilitation through the Alvis House. And those individuals then go at a 60-day interval to kind of the standalone evidence-based programs in lieu of a one-on-one with their officer. And they are things like assertive communication, problem solving, financial literacy. So it's enough to get some skills on them, but still free up probation officers. For our moderate risk individuals, the optimal caseload is 95-1. So we have 12 officers that are allocated to that function. And then our high risk is 65-1, and we have 5 officers there.
Are you meeting the standards for assignment?
We have learned in the domestic violence unit, even with these 2 additional positions, we've had to make some adjustments around our moderate risk until we're able to beef up staffing there. Where we're finding we're falling short is in our high-risk population. Our target is 65 to 1, and we're probably more like in the high 70s there. So although we are getting there, we are certainly not staffed up enough where we need to be. And actually, those numbers are the high end. Actually, it's like it should be, high risk, no more than 50 or 55, because they're doing a lot with these individuals.
So in a follow-up to that, talking about pretrial reform, what steps are you taking to ensure that low-risk, nonviolent offenders are not being held in jail, for instance, simply because they cannot post bond?
The probation department doesn't have anything to do with that. That's up to us. But we do have in the probation department a pretrial services unit that talks to, welcome Councilmember Brown, that talks to people who have been arrested and gives recommendations to the judge that's presiding over arraignment court. The court generally is working harder to release more people on recognizance with conditions and fewer people subject to money bail. There's a lot of factors. One is a lot of the people that we see in the arraignment court are people who were summoned into court in the first place and then fail to appear at some point in the time. So consequently, we generally view them as a higher risk to return. It doesn't mean that we're not going to turn them loose without supervision, but there's an incentive at that point to say, this person has shown that they're not entirely trustworthy to come back to court. If I've got a bondsman who will call them up and make sure they come, who's got skin in the game, then they are more likely to make those things. So it's a delicate balance, but we are working, we have been for the last 4 or 5 years with the Common Pleas Court, with the county commissioners to try to reduce the jail population. It's cost savings for all elements of government. It certainly is better for human beings not to be in the jail. It doesn't do any good for anybody that's in there. So we're working it, but it's an imperfect system, and I don't know that in the long run we're ever going to completely clear out the jail for the kind of reasons that I've said. Thank you, sir.
Councilmember Mitchell-Brown.
Thank you, Chair Page. Judge Burrows, part of the conversation was that other people are coming to take a look at the programs that you're doing. What makes them so special?
The evidence-based practices that our probation department adopted about 2 years ago are cutting edge. I mean, they are in place in some other places in the country, but they're not widespread. We had an expert who came in, examined what our probation department was doing, and then set forth a plan that we could adopt these evidence-based principles. And I say evidence-based, it means that in other jurisdictions where this has happened, they have been able to demonstrate a reduction in recidivism. That's the main thing that our court should be doing, is to try to get people at where they are and persuade them by hook or by crook to figure out different ways to live their lives so they do not come back to court. Evidence-based means this is something that has been tried and shown to have that kind of result. We would be foolish not to adopt something that has the potential to benefit our community to that extent, and that's exactly what we've done. It coincided with hiring Molly in as our chief probation officer. She's young, she's energetic, she brought good ideas with her, and she brought this to us. I don't want to tell you that any of us judges said, you know, what we really need to do is change the way our probation department works to do a better job. She came and said, you guys are doing this wrong and we could all do it better. And the judges listened. They backed her up. This council has backed her up so far. What we're looking is to take that to the next level and make sure that it's as efficient as it can be in doing what we set out to do, which is to improve the lives of the people in our community, including those who have been convicted of criminal offenses.
And also the conversation about the expansion of the DV unit. You need to have additional people there? Is that what the request is?
That's exactly what we're talking about. As Molly said, the DV people tend to end up in the high-risk category, and many of them are also high needs, not all of them. And the model is for those people who are probation officers overseeing those kind of people to have smaller caseloads so they can see those people more regularly, keep closer tabs on them. And it's proven out in our specialized dockets, which what specialized dockets are is we see people every week. I see those people on probation every single week. That's intensive probation. That probably maybe even more than what the DV probation officers are doing, but maybe it's exactly what they should be doing, is seeing people once a week. When people know they've got to come and answer to me every single week, they tend to keep their minds focused on what they have to do to stay out of trouble. And if they develop the habits of staying out of trouble a week at a time, then in 2 years when they graduate from my program, they have learned the lessons about how to stay out of trouble, and it shows off in reduced recidivism. We'd like to, I mean, the ideal thing would be to have so many judges that we could have everybody who we put on probation on intensive probation. That's not what's happening. But for this DV, where the risk of harm to individuals in the community is high, where the risk of reoffending is high, it's the place where we ought to focus as many of our resources as we can to help those people change their habits and become productive citizens, and for their family members and those around them to be safer. That's what we ought to all be shooting for. So having a lower ratio of probation officers to people on probation is the way that that happens, and that's an evidence-based outcome that I'm telling you about. So that's what this expansion is really looking for, is to bring ourselves into the standards that we need to be so that those people are getting the dosage treatments, is what I think that's the terminology in the
Dosage
field.
program, yeah.
That's not legal terminology, that's social work terminology. They're getting the dosage treatment that they need to be able to be successful in the program and to protect the community.
And just a question, sir. The people in the specialized units and the specialized dockets, do you ever pair up a person who you know is having problems, but they talked to someone who had similar type problems and was able to overcome them from the specialized dockets? Does that ever happen?
I'm sorry,
When you have a client who has a problem and a DV issue, and you have people you said who've already been through the specialized docket, and they have recovered, if you will, or recognized the difficulties of their problem, do you ever have people from the specialized docket spend time with people who are currently having issues and don't realize how serious it could be if they had to keep coming back in front of you?
okay, the answer to your question is not right now, but it's one of the things I'm really looking for. I run the Veterans Court, specialized docket.
I'm aware.
I knew you knew that. What I'm looking for is for somebody who's graduated from our program to come back and act as a mentor. And I've had several of them that have, and I've encouraged them. One said, I'm not ready yet. The other one's teetering on the edge of it. So over time, as we graduate more people, I'm going to be looking for those ones that I think have the gift of leadership and have learned the lessons to come back and work with my current crew. But that's separate and apart from the domestic violence request. But yes, I love the suggestion. I would like nothing better than to have a half a dozen graduates who would come back and be mentors to the guys in the program now, men and women in the program now.
Thank you.
Thank you, sir.
Yes.
And I have one quick question, just for clarification. The 2 DV positions you currently have, the 5 probation is an expansion request that you do not have currently but are requesting.
That's correct.
Thank you.
Thank you, Chair Page.
There are no further questions. We will now move on to the Honorable Lori Tyack, the Franklin County Municipal Court Clerk of Courts, and she is joined this evening by Crystal.
Okay.
Yes, so thank you both for joining us, and the floor is now yours.
Good evening, Councilmember Page, Council Members Ramey, Brown, and Judge Barrows. Thank you for the opportunity to present the 2019 proposed operating budget for the Franklin County Municipal Court Clerk's Office. I would also like to thank Mayor Ginther, Director Lombardi, and staff, and the other members of the Columbus City Council for their support. Tonight, I have some exciting news to share with you regarding our accomplishments over the past year. I will also be presenting our strategic priorities for next year. I brought with me, again, my Fiscal Administrator, Crystal Ross, and my Director of Public Relations, Marilyn Stevens, who had to step out a little bit earlier. I would like to thank them for their assistance in putting together tonight's presentation. The Clerk's Office promotes public trust and confidence through accurate record keeping and effective collection and management of funds. Funds are collected by order of the court and dispersed in accordance with the Ohio Revised Code, municipal and county ordinances, and local court rules. Annual audits are performed by an independent accounting firm hired by the City of Columbus, and annual reports detailing the daily operations, financial statements, and the caseload of the clerk's office are available online and in print for public review. The jurisdiction and caseload, I think it's important to realize that our court has both countywide and citywide jurisdiction. Land annexed by the City of Columbus extends into 2 other counties, Delaware and Fairfield. We process citations and criminal complaints for 21 law enforcement agencies and cases transferred from 19 mayor's courts. Our court has the largest volume of cases of any municipal court in Ohio. That includes Toledo, Cleveland, Akron, and Hamilton County. If you go back one slide, over the past year, the clerk's office has participated in several community service programs bringing value to the entire community. Two examples include the Franklin County Environmental Court's Open House and Hope Works. The Franklin County Environmental Court held its 4th annual open house in September. More than 20 agencies participated, giving tips and information to residents on how to become more involved in their community. The clerk's office manned the popcorn and pamphlets table at that event. And at the second event, Hope Works, it was a job fair held at the YMCA of Columbus. 15 employers and 17 service providers participated in the second Hope Works program. The program offered opportunities for employment to those struggling to find a job, to those coming out of a reentry program, or for those who just needed another chance. Judge Cindy Morehart and members of the clerk's office participated, providing case and expungement information during that 5-hour program. Currently, more than 3.3 million drivers have active license suspensions in Ohio, and of those in Franklin County, 370,000 people also have license suspensions. Recognizing the need for assistance, the Ohio Legal Assistance Foundation, the Franklin County Municipal Court Clerk's Office, and the Franklin County Municipal Self-Help Resource Center, in addition to 12 other agencies, collaborated to organize a pilot for the driver's license clinic, the first ever held in Franklin County. Information and legal assistance was provided to almost 200 citizens struggling with driver's license suspension issues. The program was successful, and it was designed as a pilot or a trial run to prepare for the statewide implementation of House Bill 336, a driver's license reinstatement fee reduction and amnesty initiative, which will be effective in 2019. We look forward to working with our partners that we established in our pilot program with this new initiative. In April of next year, the clerk's office plans to sponsor a driver's license reinstatement workshop to assist the public in taking advantage of this new House bill. The program will take place over a 3-day period at the courthouse and will be based on criteria outlined in House Bill 336. Eligibility and application information is currently available at www.bmv.ohio.gov. I'm very excited about this program, and we'll provide more information about it as soon as more information becomes available. Many programs that we participate in are held outside the office during regular business hours, but we've also implemented several internal programs which have made our operations more efficient. This past May, the clerk's office information technology staff created an automated telephone message process to remind individuals of their scheduled arraignment hearing 24 hours in advance. Since our program began, more than 50,000 phone calls have been made. In 80% of the successful calls, a message was played for a live person or left on an answering machine. Only 8.7 of those contacted successfully failed to appear in court, and an arrest warrant was issued. Of those without contact numbers, 12.6% failed to appear, and a warrant was issued. This data suggests that by making contact at least one time prior to the hearing results in a 31% decrease of defendants who failed to appear. We do plan to continue this effort to reduce the number of arrest warrants being issued for failure to appear. The clerk's office has worked collaboratively with the court, the Columbus Division of Police, and the Franklin County Sheriff's Office since 2007 to close a loophole for individuals summoned to court instead of arrested. On average, our efforts have allowed for the capture of more than 4,500 reportable fingerprints per year over the last 11 years. I would like to acknowledge and thank Chief Jacobs and the Columbus Department of Public Safety for working with the clerk's office in this initiative. We look forward to continuing this important work with them. The clerk's office also began accepting electronic filings for civil cases from government agencies, including the City of Columbus, since February of 2017. In total, we've received almost 5,000 filings electronically. We anticipate receiving the majority of our filings electronically in the next few years as we expand our program to other case types. The Ohio Expedited Record Update Service Program was a 6-month pilot program included in the amended substitute Senate Bill 66 by the Ohio Legislature in 2017. The bill authorized the Ohio Attorney General to contract with a private vendor to send electronic notification to more than 600 background check companies once courts granted an expungement or a sealing of record. The Franklin County Municipal Court Clerk's Office was awarded $9,000 by Columbus City Council to provide an opportunity for indigent defendants to participate in this program. The fee was $45 in addition to the $50 expungement filing fee. Of the 1,700 expungement applications filed, 303 applicants took advantage of the program. Only 9 received grant funds before the program ended on October 1st of this year. I would like to say thank you to Councilmember Page for her assistance in providing indigent defendants with funds to participate in this very important program. Thank you. The Clerk's Office has identified its strategic priorities for 2019. The objective of these priorities is to save valuable taxpayer dollars, better utilize staff resources, and reduce the carbon footprint of the busiest municipal court in the state of Ohio. Franklin County and the City of Columbus have set aside $12,500 each to fund a 6-month pilot for texting reminder notices to those appearing in arraignment court. The Clerk's Office has properly vetted companies who applied through an RFP process and plans to launch the program in early January of 2019. In addition, the Clerk's Office will be participating in a text message study sponsored by the Legal Design and the Reg Lab at Stanford Law School. We're very excited about this program and participating in it. Stanford will be studying whether text-based reminders are effective in improving people's attendance at court. All costs associated with the program, except for my staff's time, will be covered by Stanford. We look forward to receiving the results of this study in late 2019. Beginning in 2019, in January, the Clerk's Office plans to provide the convenience of instant communication through an online website application to expedite customer service. This additional service will be available in both criminal traffic and civil divisions by mid-2019. In an effort to expand bond payment services to the public, we have requested grant funding for 5 live agent kiosks. Customers with active warrants or their proxies may use kiosk technology to pay out delinquent amounts owed on adjudicated traffic tickets or for an enforcement of costs or fines and fees. This additional service will reduce jail overcrowding by allowing law enforcement to implement a catch and release process. Those taken into custody on a warrant may pay bail and be released in lieu of being slated into the jail. Reduction of nonviolent offenders in jails provides value to customers and the community, allowing law enforcement to more effectively focus on violent offenders. Good evening, Councilmember Stinziano. The ultimate goal of electronic filing is to reduce the dependence on paper documents and create a more efficient process for document retrieval. Over the last several years, my staff has been working to adjust from a paper product to an electronic workflow. The process is complex, but I believe it will be well worth the wait for all of our customers. Next year, my office plans to expand civil filings to accept evictions, contracts, and personal injury. We'll also begin accepting electronic filings of criminal complaints and case filings associated with criminal traffic cases, and electronic citations issued by multiple law enforcement agencies in Franklin County. My staff is currently testing software provided by the Ohio Highway Patrol. Equivant, the owner of CourtView, our case management system, has been working to integrate our 2 systems so that the data can travel from one system to the other without any time delay. So we're very excited about that possibility. Less individuals will be needed to do data entry at the time, and it will become mostly quality control checks to make sure that all the information was reported correctly in our system. So far, the Franklin County Sheriff's Office, Upper Arlington, and a few other local jurisdictions have expressed their interest in the system. And I'm very pleased to announce tonight that the Columbus Division of Police will be on board as soon as we go live. So go CPD. Thank you so much for your commitment. And now briefly on the budget. The clerk's office budget for the proposed operating budget is $12,745,502. $11,818,682 was allocated for personnel, $139,734 from materials and supplies, and $787,086 for services such as postage and fleet. In comparison, the budget provided by the city's Department of Finance and Management was $12,534,164 million, for a difference or a shortage of $211,338. In addition, the clerk's office has been asked to take a 4% vacancy credit as opposed to the little over the 3% that we voluntarily requested. The difference is $479,825 we're being asked to absorb, and the difference between what we asked for and finance's request is $83,580. This cut requires the office to do without the equivalent of almost 9 employees. And just to put this into perspective, 8 staff members currently serve on second and third shifts respectively. The work performed during these shifts includes critical duties such as preparation of the court's daily docket and providing real-time information to law enforcement in the field. This reduction in budget funds could potentially wipe out an entire shift in the criminal traffic division of the clerk's office. I'm especially concerned about these cuts because the Ohio legislature continues to burden the courts with unfunded legal mandates. It is no longer about doing more with less. We are at a tipping point where doing without adequate staffing levels is disruptive to our daily operations. Therefore, I'm respectfully requesting a full restoration of my proposed budget. On to the computer fund budget. The clerk's computer fund request is a separate budget request for technology-related requests. It includes $719,772 for personnel, $61,000 for materials and supplies, and $815,190 for professional services and contracts for a total of $1.5 million. This fund is supported through court costs according to state statute and is approved by our administrative judge annually. Good evening, Councilmember Brown. In 2006, the City of Columbus loaned $2.6 million to the city's clerk's office for the purpose of imaging and disposing of 13,000 boxes of case files that were being stored in the municipal court building. And just to give you a perspective of how much weight that is, the 18th floor is slightly bowed now because of all the boxes that were stored there at the time. So we're very pleased to announce that we now have over 40 million documents available electronically for retrieval, and as of this year, our total debt amount has been repaid to the city. So thank you so much for working with us to achieve that wonderful conversion to electronics. We do have 2 expansion requests that were submitted to the Director of Finance. The first is a request to transfer 6 technical specialists from the computer fund to the general fund. And the importance of this, we've asked for this for the last several years, but the importance is so that those personnel costs can be relocated to the general fund so that we can more effectively cover our technology-related costs. Good evening, President Hardin. The second request was to add 1 additional court view specialist to our IT staff. We're currently operating with only 6 staff members. We serve over 400 users in our building and some outside our building. We started in my term with 12 technology specialists, and we're down to 6 now. We really need to start adding those back into that budget so that we can effectively use those staff members to support our customers. We also, in addition to the 400 users, we field daily information requests from the public, the news media, city, county, state, and federal agencies. Every time the FBI comes into my office, I get a little bit nervous, but they flash their badges and they just want to look at the files. So we work with them on a weekly basis to provide requested information. The additional position is truly imperative to our daily operations, and I'm respectfully requesting reconsideration to create and support this position. As far as the collection of court costs and fines, the court orders us to collect court costs and fines based on their orders to defendants. We contract with 4 collection agencies currently to collect in that debt owed the court. And in 2018, over $4.3 million of unpaid fines, costs, and unpaid bonds from individuals who post bond for another individual were referred to these agencies. The total recovered as of the end of November was a little over $1.1 million, with a collection rate of approximately 26% overall. And that's average for most of the clerks in the state. There are certain circumstances where collections are recalled, cases are recalled from collections. Those include when the defendant is arrested, if there is a scheduled court appearance, and whether the defendant has committed a probation violation, or if the defendant files for bankruptcy. The total amount recalled in 2018 by the court was $542,798. And in summary, I just want to say that we are committed to working with the City of Columbus to stay within the budget constraints that we've been provided. We are, however, down to the bare bones when it comes to the operating budget and the staffing levels that we currently have. The cuts to the proposed target budget and adhering to the increased vacancy credit will be very difficult to accomplish. For the reasons I provided tonight, I'm respectfully requesting City Council restore the cuts to my proposed operating budget. Councilmember Page, I want to thank you again for your unwavering support of the Clerk's office during your tenure on Columbus City Council. My staff and I appreciate the time and attention you've given us to assist us with our needs, and we wish you the best of luck in your new endeavor on the Common Pleas Court. Lastly, I want to thank the citizens of Columbus and Franklin County for the opportunity to serve as your Franklin County Municipal Court Clerk. I'd be glad to take whatever questions you might have for me. Thank you.
Thank you, Clerk Tyak. Are there any questions from my colleagues? Councilmember Mitchell Brown.
I'm sorry, can you ask a little bit louder? What percentage?
Your budget in 2018 versus what you're projecting your budget should be in 2019.
It is about 2%.
It's about 2%?
Reduction, yes, in what we received last year to this year.
And when you issued your budget request, was it in that arena? Was it more than the 2%? I haven't had a chance to talk to the finance director yet, so that's going to be an issue for me.
2.2% change in last year's budget to this year's budget. And you're asking whether the budget that they...
Just based on what you requested and then subsequently what was offered to you from a budgetary standpoint, and you're saying it was like 2%. So we would have to spend time with the finance director to figure out how we could come up with that 2% somehow based upon your needs and what you've been able to do for this, for Franklin County and certainly for the city. So
correct.
Just to get a sense of that.
Thank you.
Okay, thank you.
Thank you, Councilmember Brown. Are there any other questions or comments from my colleagues? President Harden.
Thank you, Chair. Just would just encourage the clerk of courts to continue working with the chair and report back, and I'll work with the chair to report back to council on any before we pass the budget.
Great. Thank you so much.
Yep.
Thank you, President Harden. And I believe that you have a meeting with the Finance Department within the next week or so, is that correct? To go over the proposed budget in areas where the budget was cut. So we look forward to updates after that meeting as well.
Thank you.
Well, this concludes our public hearing on the Judiciary and Court Administration Committee proposed 2019 operating budget. I would like to thank all of those who attended to testify, and also thank Matthew Erickson and my team, Rolanda Hampton and Charles Newman, for putting this hearing together, and thank all of my colleagues who attended. Everyone have a good evening, and thanks again.